The rules of this panel discussion is as follows. Presenters have 30 minutes to give their speech. The presenters will be given a 28-minute reminder with a short bell ring. When the 30-minute time limit is up, the bell will ring twice. The presenters should then end their speech. The discussants will be given a 13-minute reminder with a short bell ring. When the 15-minute time limit is up, the bell will ring twice. The discussant should then end their discussion. Afterwards, we will have a 20 minutes Q&A. Each question in the Q&A session is limited to 2 minutes. All persons who would like to join the Q&A shall identify themselves by stating their name, the affiliated institution, and their title before presenting the comments or questions. There will be a 1.5-minute reminder with a short bell ring, and the bell will ring twice when the time is up. The attendants should then end their questions. If you wish to join the Q&A, you may use the microphone in front of you. Please press the button on the microphone while you speak, and remember to turn it off when you finish. If you have other questions or opinions, you can also use the speech notes placed inside the folder and pass it to the staff near you.
The topic of the third panel discussion is the latest development of the right of information privacy. Let us welcome the Honorable Justice Huang Zhaoyuan to be the moderator of this session.
Good afternoon, ladies and gentlemen. I'm so excited to be the moderator of this session partly because this is the last session of the 2-day-long conference. So that's why I'm so excited, and I'm sure many of you should share my excitement as well. And well, I would like to thank everyone in this room to stay around until now, and it has been quite a long way to go. And the theme of this session is on the right to information privacy, and we are honored to have two very distinguished scholars to present their paper, and another two a little bit slightly more senior researcher to comment on their works. The order of proceeding this panel will be like this. I'll ask our two presenters to present their paper first, and then I'll turn the podium to the both discussants. And first of all, let me introduce the both presenters briefly. The first presenter is Professor Leo Chingy, who is an associate professor of law at National Zhengzhi University. Professor Leo received his PhD from George Washington University of the United States. His research focuses on constitutional law, communication law, and administrative law. The second presenter is Professor Wong on my right-hand side, Wong Yihong. He's an assistant professor of law at Shixin University. Professor Wong received his PhD in law from Durham University of the United Kingdom in the year of 2013. And his main research field and subjects includes privacy law, internet and telecommunication law, European human rights law, and bioethics. So I'll invite the Professor Leo Chingy to present his paper first. So with my introduction, let's welcome Professor Leo.
Justice Huang, my fellow panelists, Professor Wong, Professor Liu, Professor Cho, President Xu, distinguished guests, ladies and gentlemen. It's my great honor and privilege to participate in this historic event. I'm really excited that the Judicial Yuan chooses information privacy as one of the topics of this symposium. In recent years, rapid advances in technology has forced us to rethink the right to information privacy. We have seen new developments in this area of law around the globe. It's really a good time to review how we got here, what is the current status, and what the future may be regarding the right to information privacy. In the past years, we have frequently heard these big words like big data, Internet of Things, and artificial intelligence. There is one thing in common behind all these concepts. They all involve the collection and analysis of huge amount of data. Most of them are personal data. Countries around the world are facing information privacy issues, especially when they wish to tap into big data, IoT, and AI. And different countries have adopted different approaches to tackle these issues. But the main thing is very clear. As technology advances, the law needs to be updated. This remained unchanged since the very beginning when the concept of the right to privacy was brought up. In the 1890 article, The Right to Privacy, the authors mentioned the improvement of photographic technology, as we see in the slide. Around that time, the Kodak company launched a handheld camera. So, for the first time, it is possible that people can be photographed without their knowledge. So the law needs to address this issue. Similarly, the right to information privacy is a direct response to the innovation of computers and internet. In the era of computer databases and internet, personal data can be easily stored, easily processed, and easily disseminated. So the big issue we are currently faced is what should the law react to big data, IoT, and AI. As these technologies promise to bring huge benefits, such as individualized service or new treatment for diseases, the potential risks are hard to ignore. Before answering these questions, let us quickly review the past development. In the United States, after the publication of the article, The Right to Privacy, the right gradually gained support in state tort law. However, at the federal constitution level, it has mixed development. Decisional privacy, for example, decisions regarding child rearing or procreation, and physical privacy are well accepted by the Supreme Court, at least now. But informational privacy is a different story. Although two 1970s decisions, Whelan versus Roe and Nixon versus Administrator of General Services, touched upon a constitutional protected interest in avoiding disclosure of personal information. The Supreme Court in a 2012 case called NASA versus Nelson merely assumed the existence of a constitutionally protected information privacy interest. So therefore, whether the US Constitution protects a general right to information privacy is unclear. The right to information privacy has a firm constitutional basis in Europe. The German Constitutional Court took the lead in recognizing a constitutional right to information self-determination in the census case. Beyond the borders of individual European countries, the Charter of Fundamental Rights of the European Union not only protects the traditional right to privacy, which reads, everyone has the right to respect for his or her private and family life, home, and communications. But the Charter also has a separate provision to the protection of personal data. Most importantly, as we can see from this slide, how to effectively protect such right has itself being constitutionalized. We can see Section 3, Article 8 of the Charter states that compliance with this rule shall be subject to control by an independent authority. It is really remarkable to have this detailed mandate for the protection of a specific basic right. Back to Taiwan, the right to privacy is a newly recognized right. We first recognized an information privacy interest in a statute called Computer Processed Data Protection Act in 1995. 4 years later, the Civil Code was amended to include privacy as one of the examples of the personality right. And in 2004, the Constitutional Court of Taiwan elevated the right to privacy to be a constitutionally protected basic right. However, it is rather interesting to note that between 1999 and 2004, that is, between the adoption of the privacy right in Civil Code and before the interpretation number 585, there are only a handful of Supreme Court judgments, civil judgment of the Taiwan Supreme Court mentioned the word privacy, and only one explained the concept of privacy in detail. So therefore, we can say that before interpretation number 585, the right to privacy did not get much of the attention in legal practice, even though the right has been protected by various statutes for almost 10 years. So what is the right to information privacy as recognized by the Taiwanese Constitutional Court? First, it's an unenumerated right protected by Article 22 of the Constitution in order to preserve human dignity and individuality. It includes a set of substantive rights, as we can see on this slide. And in interpretation number 689, the Constitutional Court explicitly states that individuals can have reasonable expectation of privacy even in public places. I think this last point deserves our special attention as we consider modern information privacy issues such as the right to be forgotten. This interpretation will be very useful since some of the information we wish the world to forget is already in the public domain. So as we have seen the past development in 3 regions, how do we explain the divergence mentioned above, especially the differences between the US and Europe? Some scholars argue that it's because the Europeans emphasize dignity while the Americans value liberty. And the Europeans are more skeptical about free press and market power. Thus, as the right to information privacy is about empowering individuals to control their information, the implication of this right on freedom of expression may prevent the US courts from accepting it. But how about Taiwan? Taiwan's experience is unique, I believe. Here, we emphasize both dignity and liberty. Freedom of expression is strongly protected by the Constitutional Court. However, I will say that it may not be in a preferred position when balancing against other interests, as it is in the United States. As a result, the right to privacy has more room to develop than that in the United States. Most importantly, I think the authority and the legitimacy of the Taiwan Constitutional Court to identify unwritten rights have not been seriously questioned so far. The only exception I can think of is the recent same-sex marriage case. So with this background, the Taiwan Constitutional Court is freer to shape the contour of the right to privacy and the right to information privacy. So next, Let us see what the law has changed in response to big data and other information technology. In the US, just 3 months ago, the Supreme Court rendered a decision, Carpenter versus United States, which addresses, as the court put it, the seismic shift in digital technology. The court ruled that individuals can have reasonable expectation of privacy on historic cell site location information. The police are required to obtain a warrant before accessing this kind of information. Although it's a Fourth Amendment case, it is significant still in the information privacy law because the decision declined to extend the so-called third-party doctrine to historical cell site location data. The third-party doctrine, which means that people cannot have reasonable expectation of privacy in information voluntarily disclosed to a third party, has long been seen as an obstacle in developing a broader right to information privacy in the United States. So I think this decision is rather encouraging. But we should note that the majority opinion is very cautious about dealing with new technology. As Chief Justice Roberts cautioned in the majority opinion, when deciding cases involving new innovations, the court must tread carefully in such cases to ensure that we do not embarrass the future. Therefore, the Carpenter decision is a narrow one. It does not address the issue of real-time location data or other innovative surveillance techniques. It does not address information collection project in the context of foreign affairs and national security. So in Europe, however, the right to privacy and right to protection of personal data have been well established and rigorously enforced, as we've seen in the Digital Rights Ireland case. Meanwhile, the completely overhauled General Data Protection Regulation, the GDPR, went into effect this May, setting a new world's information privacy standard. First, it reaffirms the individual control model of personal data protection. It recognizes some new substantive rights, such as the right to be forgotten. Of course, these rights are not without controversies. Scholars have warned that the right to be forgotten will clash with freedom of expression. But as Professor Wong devotes his entire article to discuss this topic, I will say only this. If we understand the right to be forgotten as some kind of digital redemption, I believe this right can be accepted in different countries because the idea that people deserve a second chance under certain circumstances exists in different cultures across the globe. Thus, the right to forgotten only requires us to carefully reweight and rebalance the competing interests in the digital age. In addition to new substantive rights, the GDPR also emphasizes organizational and procedural safeguards. It requires data protection impact assessment and independent data protection officers. Furthermore, GDPR includes some new concepts, such as pseudonymization, and it loosened the storage limitation principle and purpose limitation principles. These provisions together allow data controllers to harness the potential benefit of big data analytics. So back to Taiwan again. The Personal Data Protection Act has been amended twice in recent years. However, the Act does not address the issue raised by big data, IoT, or AI. So how to implement the right to information self-determination in the era of big data is a big issue here. I think the dispute over the use of National Health Insurance Database vividly illustrates the challenges we faced. I will only point out 5 important issues in this case. First, I think the interest balancing in this case is very difficult. I will say it is far more difficult than that in interpretation number 603, the case concerning mandatory fingerprinting requirements before issue national identity cards. Second, there is no prior privacy risk assessment before the implementation of the project. Third, transparency of the project is also an issue here. Most importantly, whether the existing individualized notice and consent scheme can be maintained or how should it be modified is a big problem. Finally, whether the administrative court, without a full administrative records or privacy impact assessment report, is capable of deciding complex technical issues such as anonymization, re-identification, is questionable. So, what is the future of the right to information privacy in Taiwan? Traditional information privacy paradigm emphasizes affording individuals with substantive rights and post hoc remedies. This paradigm faces 2 challenges now. In this field, the technology is constantly changing. So a rigid substantive right approach can hardly catch up with it. Most importantly, experiences have told us that individuals can seldom meaningfully exercise their substantive rights in the field of information privacy cases. So, how do we address these challenges? I believe we should focus on the following 3 aspects. First, we may need to have a constitutionally mandated supervisory mechanism. Information privacy harms are very special. They often involve covert intrusion and non-tangible, uncertain future harms. So individuals lack expertise and motivations to protect themselves. In addition, government itself is the single biggest personal data controller here in Taiwan and around the world. Without independent oversight, there will be no effective protection. We should know this very well. As we learned from our own experience, the under-enforcement problem of the Personal Data Protection Act here vividly illustrates this point. Secondly, I think we need to establish the data protection due process. The burden should on the data controllers to justify their data processing projects. They need to actively notify the people regarding their plans. Individual concerns, as well as the general public, should have an opportunity to be heard. A constitutionally mandated hearing will ensure that information practice can indeed achieve asserted public interest and the method employed to protect individuals' privacy will be effective. The process can also help form a consensus and increase the acceptance of such information practice. Lastly, we should leave enough room for the legislature and ordinary court to develop new information privacy norms. I believe that some categories of personal data may require different sets of rules. So a broad, one-size-fits-all regulatory scheme may not be a good idea. In the field of medical information, telecommunication information, or data processing for law enforcement national security purposes, separate laws should be seriously considered. In addition, I will urge the Constitutional Court to take a wait-and-see approach regarding newly recognized rights, such as the right to be forgotten or data portability. Ordinary courts and administrative agencies, such as Taiwan Fair Trade Commissions, can deal with these issues on a case-by-case basis. Ordinary courts routinely handle disputes involving conflicts between free speech and the right to privacy. There are good reasons to believe that they are capable of striking a proper balance in accordance with specific facts of the case. The Constitutional Court can learn from their experience and act at a later stage. This approach, I believe, will ensure that the Constitutional Court has a better understanding of the impact of these new rights on relevant parties, and especially the impact on the development of new information technologies. So to sum up my presentation, I think we should strive to find a suitable approach based on our own experiences and our own needs. Such approach should effectively protect individuals' right to information privacy, building a trust atmosphere in the processing of personal data, while allowing the people to harness the potential benefits of advancement in technology. Thank you very much.
Thank you, Professor Leo, for your precise and time-abiding presentation. And I'll certainly take a wait-and-see approach and to see and let the commentator to comment on your presentation later. And now I will turn to our next speaker, Professor Wong Yi-Hong, to present his paper also in 30 minutes. Professor Wong, the podium is yours.
Thank you. Good afternoon, dear judges of the Constitutional Courts. Courts, because we are having a guest from the Mongolian Constitutional Court. So, and distinguished guests, it's my greatest honor to be able to deliver a presentation today. As the last presenter, it is my job to shorten the long day as soon as possible. I'll try this best. So, as this is the first draft of the essay, so I think I will revise it maybe later. So because I've just realized that the other presenter and the commentators are all from they got their PhD degrees from the USA. So suppose they adopt the US data protection model. And I've just realized yesterday that my commentator has a very different points of view in relation to my essay today. So I will divide my presentation into 5 parts. This will include the first part of introduction to set the scene, and the last part of conclusion. I will introduce a theoretical framework, firstly, mainly include the so-called the EU data protection model and the data subjects autonomy and the real conception of rights. Then I will try to analyze the notion of the right to be forgotten. Then I will try to introduce a theorized regulatory framework, mainly focus on the regulatory and institutional framework. So the first part will be the introduction part. The main research purpose of this essay is to analysis about the GDPR, and particularly on the ideas and concepts of the right to be forgotten. I've got 3 main research questions. The first one is to identify and justify an adequate theoretical framework to evaluate the current GDPR. Then I'll try to examine the potential balance between the competing rights and technical applications. Finally, I'll try to produce a theorized regulatory framework for Formosan data protection law regime. So firstly, I adopt the European data protection model. However, I think most of the issues come from the dilemma between promoting free flow of the personal data to function internal market of the European Union itself and protect the fundamental rights and freedoms of the nature persons. Now we can see that from the Google analysis report, the right to be forgotten seems to be very needed in recent years. However, it must be emphasized that most of them will not actually get from all those request data to be removed were not consent-based data collected by the data controller. The meaning of the European data protection model is that we should, before introducing the GDPR, I do believe that the interpretation of the Data Protection Directive and the GDPR must take the ECHR into account. Why? Partly maybe because my supervisor, Paul Quake, said in his book that the ECJ or the CJEU is willing to look closely at the relevant ECTHR cases law for guidance. The situation remains the same after the GDPR. It is therefore essential to understand how the ECTHR examines the ECHR, in particular Article 8 regarding the right to private life. In the ECHR approach, we've got the so-called constitutional approach to look at the Article 8. I think there are 3 main stages. The last stage of the so-called constitutional approach of the ECTHR is try to have a balancing test approach, which requires the evaluation of the principle of proportionality. However, it should be noted that the principle of proportionality is difficult to ascertain exactly what local courts should be taken into account to determine the hierarchy of protected rights and interests when developing domestic human rights law. This happens in the circumstances of conflicts between the right to be forgotten and other fundamental rights and freedoms, mainly the right of freedom of expression. which has been protected in Article 10 of this ECHR, and the right to know as such. Theoretically, I adopt the will conception theory. In this theory, under this theory, a data subject, the most crucial thing is to be able to have the ability to control the data in relation to him or her. The other agent in this regard categorically ought not to interfere with an agent having the fundamental needs against his or her will. A role for the government, moreover, while running the dangers of the concentrating power in the hands of the few, to take positive action to enhance the freedom of their subjects. The data subject does not have duties to protect, however, or at least not to harm their own generic agency interest if he or she, the agent, does not wish to do so. However, such a waiver should not endanger, again, equally or more important generic rights or interests of other agents. Moreover, such a waiver should be based on permitting an informed agent to engage freely, which reflect the freedom of choice in activities that are not favorable to the interest of the agent protected by the fundamental rights and freedoms. The third part of the essay is to try to analyze and try to figure out what is the notion of the right to be forgotten. Back to Taiwan, the right to privacy and data protection in Taiwan is kind of overlapping, but not all the same. The PDPL, which has been introduced by Professor Leo Chingy, itself aims to govern the collection, processing, and use of the personal information. I mean, personal information is kind of weird here because in my understanding, PDPL means personal data. However, in the translation, we still use the Personal Information Protection Act. I have no idea why. Yet, uncontrolled utilization of the technology and its applications thus can come into conflict with the protection of fundamental rights and freedoms of individuals. It's harmful to the agent to diminish or weaken the protection of such legal interests. To face the challenges, a series of new rules has suggested and proposed in a proposal in order to get more power of control for data subjects themselves, including the right to be forgotten. However, we must understand that actually the right has a very vague notion. I think it is crucial to distinguish the right to be forgotten and the right to forget. The default is now to remember. However, the very famous scholar said that the technical solution of the expiration dates may exist to deal with this. What means the expiration dates in the GDPR has no longer necessary in my point of view because it has been fully adopted by the GDPR. The problem is that if an agent chooses to preserve her own data forever, it might not be a good idea to have it automatically deleted as an expiry date way, because the waive of a right by an agent should be always careful. The right has already been implicated versus subtly but important different from the original right. From these two different set of rights, we can distinguish the right to be forgotten and the right to delete. The problems here are first of all, it is impossible, almost impossible to impose duties on people to forget. And a rejection of the society and something ultimately, it seems to be undemocratic. I think some people say that the two rights are not the same because there are few reasons. For example, the first reason will be performing an extra privacy relevant function as the main mission or main function of the right to be forgotten. And then forgetting does not involve deletion. It is not necessary for the data subject to show that he or she has been harmed or the information is prejudicial. Or somebody would suggest that the duty to apply the right to be forgotten is merely obligated to index the linkage of the webs. However, some people would say that the two rights are the same, because according to the Article 17 of the GDPR itself, the given title, the right to be erasure, is followed by a reference to the right to be forgotten between the brackets. And then take responsible measures with consideration of the circumstances at issue is to inform all data controllers who are further responsible for the data processing that all links to this personal data. And then people will say they are the same rights because neither the right to delete or the right to be forgotten in any case is an absolute right. In Taiwan, however, the current legislation, namely the PDPL, is not identical to the GDPR with respect to the right to be forgotten. This is because the assessment needs to be carefully made on a case-by-case basis with a dynamic and a rather uncertain relevance for competing rights here. In the first part of this essay, I will discuss how to have a theorized regulatory framework on the basis of the theoretical framework I've just introduced. The first thing first, under the principle of purpose of the PDPL and actually the GDPR, the function creep, which means further unintended or unnecessary processing of personal data in a way incompatible with the original purpose for which it has been collected. And the idea of profiling, which refers to the profiling of individuals' behavior, which relates to one's information privacy by linking individuals to personal data. If you combine them together, you'll realize that the right to be forgotten is actually a legal idea with legal consequences rather than a technical idea which can never be achieved. The scope of the right forgotten, therefore, I suggest in my argument, I would say that not only the deletion of the original personal data documents or materials and deleting websites from the search engine to have a search result changed, but also include the profiled information, whether the profiling is processed by AI or any other machine automatically thing or sorts of things. I suggest that there should be a need to reaffirm the European model in the Formosan data protection regime, which is quite different from Professor Liu Chingy's proposal. I think because it's not prohibitive but welcomed and improve the European model may be able to improve the information flow, and the benefits of this right can be waived by valid consent under the well conception, and most important of all, actually, the Taiwanese data protection law regime, in fact, adapts the European data protection model mainly. So the second proposal would be that we should have an independent supervisory authority. An independent supervisory authority can do something more professional to specific technologies, and it is being able to easier to make quick and targeted responses, and then to solve the issues regarding a flexible model in Taiwan currently, which is kind of Hydra-headed model. So my conclusion is that I suggest to understand the GDPR, which is essential to understand how the ECTHR examines the ECHR. And I do think that the right to be forgotten is the right under the will conception. The right to be forgotten should be, the notion of it should be interpreted as the same idea as the right to delete, but strengthening the right to erase. I do think that the right to be forgotten is not an absolute right, of course. Reconciling the competing right is never easy. However, assessment needs to be carefully made on a case-by-case basis with a dynamic and rather uncertain relevance for competing rights. Lastly, I should emphasize that the right to be forgotten is actually a legal idea with legal consequences rather than a technical idea to force everyone to forget something, because it's nearly impossible for the so-called collective memories. Finally, to produce a coherent theoretical regulatory framework, I think it's supposed to do something to cover the scope of the right to delete, should not only include the deletion of the original personal data, but also the profiled information. So I do suppose that there is a need to reaffirm the European model, and then it is important and it is crucial to have an independent supervisory authority, DPA. Thank you very much for listening.
Thank you, both Professor Leo and Professor Wong, for your wonderful presentation. Well, indeed, as a reader, I must say, both of your papers are quite heavy to read and heavy to digest within a short period of time. So that's why we invite two senior researchers to comment on these two papers in the hope that they will guide us through your papers. And then before I turn to our discussion, allow me to give a brief introduction of both of them. The first discussion will be Professor Leo Leo Chingy. She's a professor of law with the Graduate Institute of National Development at National Taiwan University. She received her JSD from the University of Chicago, and her research focused on the information and telecommunication law, human rights law, and common law, constitutional law as well. And our second discussion commentator will be Professor Chiu Wen-chong from Academia Sinica, Institute of Law. Professor Chiu received his SJD from the University of Virginia in the year 2004. And her research focused on the privacy law, bioethics, medical ethics, public health, and law. So with my introduction, let me invite Professor Leo Leo Chingy to comment. Thank you.
Hello. Yeah. Thank you for the introduction. Good afternoon. I'm sorry, I'm still on New York time. Yeah. It's my great honor to do the comment job. And Professor Leo Chingy is actually one of our leading experts in Taiwan's information privacy law. I think his paper on the development of the right to information privacy, especially from the comparative law perspective, does provide us with some very useful guidance for our understanding on the conceptual history of the right to information privacy and the challenges it faced right now. So I think viewed from this perspective, Professor Liu or Dingji is much easier. Okay, Dingji's observation and suggestions about the future of the right to information privacy is a very nice roadmap for us to understand how we can adequately protect the right to information privacy and harnessing the, the potential benefits of modern information technology at the same time. So as I have the privilege to read the paper in advance, I would like to share with Dingji about some of my observation, and well, you can just take it as some supplement to the paper. Okay, the first point is about the privacy perils or privacy concerns of our open data policies or initiatives. I think everybody knows that the past decade has witnessed a very strong web of open data initiatives or open data policies. And in my sense, it goes without saying that privacy should be in the center of debates when we make any kind of open data policies. In other words, a comprehensive data protection program, I believe, is the key to the fulfillment of promises that open data advocates have pictured. So I would love to learn from Dingji about his ideas or his points about the case of Taiwan's open data policies, especially how he will evaluate the initiatives under the regulatory context of the current GDPR or the current regulatory change we are actually undergoing right now. The second point is, or the second big issue in our privacy law is the protection of sensitive personal data in Taiwan. It seems to me that Dingji's observation on our law focused on the struggle between old laws and the new technologies. But I would like to add that several major flaws in our PDPA or PIPA, yeah, just give me a break, are actually the origin of the struggle we are having. The first point is that I do think the insufficient protection of sensitive personal data is a key controversy of PDPA. And it gave rise to a lot of dilemmas we are having right now. Okay, I think Dingji are very good at, about the controversies or the debates between the Ministry of Justice and some of the NGOs. So my point is, in the context of open data in which the protection of mechanism for personal information privacy, such as de-identification and informed consent, should be taken into account into a more serious consideration. And our current PDPA does not only fall short of closing the loophole of the law, but also, increased risk of personal privacy violations. So let's go to the point of, the de-identification. Dingji has mentioned the NHIA case as I can remember. And so it seems to me necessary to talk a little about the de-identification controversy in our country. Although the purpose of the PDPA is to protect personal information, but the law has only addressed the issue of de-identification in a very, very general way. So we have a lot of, debates on this issue. For example, is the de-identification strong enough if the data subject could not be identified at the first glance of the information? Or the de-identification should be irreversible, that the data subject cannot be identified even when the data is combined with other data sets. So in other words, I believe our PDPA does not provide sophisticated requirements of de-identification for different kind of data and for various contexts of data reuse. So as a matter of fact, both of the NHIA case and ETC case reveal the same thing. The first thing is the ambiguity about the de-identification in the PDPA. And this has allowed the data collectors and the processors certain leeway when they conduct de-identification to meet the current legal requirement. The second big problem is, under PDPA, it could be the data providers or the collectors who de-identify the data. So this kind of ambiguity of responsibility could result in that both the providers and collectors share the burdens of de-identification and bring about a lot of dispute. This is another big part or big controversy in our law. The next point I would like to make is that we also have a lot of problem with the right to consent and opt-out. I think everybody will agree that informed consent is an important mechanism for individuals to control the flow of their own data. But under our current PDPA, I would say that it has lifted a requirement for written consent, except for collecting sensitive personal data. And now, when you are dealing with non-sensitive personal data, the data collectors or providers do not need to obtain written consent. Only consent will surface. So this is one of the big problems. The second problem is from collectors' point of view. If they want to obtain consent, when a large number of data subjects are involved, such as the situation of open data, that would be comparatively easy. But for data subjects, that means that they will not have a right to refuse their own data being used without clear consent. And even worse, our PDPA does not give data subjects a right to ask data collectors or providers to stop using their personal information data. So I would say that as the NHIA decision reveals, the Supreme Administrative Court in Taiwan still ruled that data collectors will have some kind of favor, in this kind of case, and the public interest will trump individuals' right to their information privacy. So let's go to the ambiguity of public interest in Taiwan's information privacy law. The term of public interest has appeared for many times, I guess. I just cannot remember the number in our PDPA, and actually has served as a very strong exception for data collectors and providers to be exempted from certain legal obligations. I will not go to the details. What I would like to say is that the controversies caused by the term of public interest in our regulations are actually its vagueness and the danger of overexpansion of its application to situations that many, endanger data subjects' information privacy. And under Taiwan's historical and social context, in which the government actually has had a long history of using the excuses of maintaining social order and promoting administrative efficiency in policing its people. I would say that the risk of excessive use of public interest by data collectors and processors are very high. So I would like to hear from Dingji about what we should do about this kind of situation. And the last point I would like to make is that I do believe a strong set of sophisticated data protection regulations is a bedrock of a robust constitutional right of information privacy. And the law we are having right now are very weak, okay? So I have raised several issues about our current law, including the inadequate requirements of consent and the failure to protect data subject, the lack of a strong opt-out device for data subjects, and obscured the identification requirements and the vagueness of the term of public interest in our law. I would like to say that, to sum up, I agree with Dingji's observation in his paper, almost on every point he made. But I would say that Taiwan should strive to find a nicer approach that can effectively protect individuals' right to information privacy. However, information technology, no matter it's big data or AI or any fancy big words in the future, might cause a lot of hazards if it is not carried out without a more complete plans for privacy protection in hand. So a good privacy protection plan will require the mindset of change, a change of mindset that recognize the importance of information privacy and a robust framework for the protection of information and a more comprehensive legal mechanism. So I would say that to keep the momentum of information technology going in a more balanced way, what we need is a strengthening of information privacy protection, and is an urgent must-do for Taiwan right now. Thank you.
Thank you, Professor Liu, for sharing your thoughts and some very critical reflection on this issue, and also on another Professor Liu's paper. I'm sure this Professor Liu will have something to respond to that Professor Liu's comment. But before doing that, I invite Professor Chiu Wen-Cong to give his thoughts and comments on Professor Wong, and he's going to use the PowerPoint too.
Justice Huang and my dear colleagues of the panel, to Professors Liu and Professor Wong, distinguished guests and Honorable Justice of the Constitutional Court, and ladies and gentlemen, it's my pleasure and honor to be here as the last commentator of the last presentation, so I need to be short. Okay. But before I go to my commentary, I would like to say something to Professor Wong first. Professor Wong used to work with me, so he is very nervous about me going to criticize harshly on what he wrote. But with this nicely written long article, I think Professor Wong should keep calm relax, sit back. It's just a friendly challenge, okay? All right. Now I shall begin my commentary. Although it sounds like an oxymoron, forgetting is a very important function of human memory mechanisms. By reorganizing the content of what humans remember, forgetting allows humans to filter and delete part of the brain's stored information, keeping each person's limited memory for the most important and the most relevant matters. In addition to the reasons of efficiency, the limit of memory also keeps our mental health in good shape by selectively remembering happy experience and forgetting negative one. Although the society as a whole needs to keep its collective memory through writing, narrative, or the preservation of space or architecture for those things that should not be forgotten, it also depends on the physiological limits of personal memory in order to function properly. For example, we don't have to worry that every bit of our daily life is remembered by everyone whom we meet only occasionally, so that we can live a relatively tranquil life. We don't care too much about the stupid things which we did in the far past will be kept replayed and reminded again and again. Being forgotten, therefore, means a state of not being marked by others and a possibility of restart a life all over again after time passes and situations changes. Now, thanks to the almost unlimited data collection and storage technologies, a sea change of the memory capacity that human can control and deploy is happening. 24 hours of uninterrupted street surveillance video. Video recorders installed in many automobile cars, mobile phone cameras that everyone carries with them. All these devices constantly record all kinds of events in daily life. The e-tag, GPS, and mobile phone continuously send out location signals that can be received and logged by system operators. Other information, such as preference tags, secretly attached to users who are browsing websites. Profiles of users' reading preference or like and share patterns collected by social networking providers such as FB. Electricity use habits recorded by smart meters provided by the power company. Consumers' purchase records that the credit card companies retain. Telecommunication metadata created and maintained by the telecommunication companies. Medical information collected by the National Health Insurance Administration and also the private companies. All these data sets are just the tip of the iceberg of the collection of very detailed information that one can imagine about every aspect of a person's life. It's not, the list is not even include the facial recognition or the IoT the Professor Leo just mentions. In a nutshell, the latest development of information technology have not only made everything leave traces, but also made those traces literally unforgettable. We do have a right to erasure of personal data, a right to request deletion of personal data. which can be used to prohibit further processing of personal data in certain conditions. For example, in Taiwan, the right to request deletion of personal data will be honored when the specific collection purpose no longer exists, or when the authorization of data use expires, or in cases when the data collection, processing, or data use is in violation of the provisions of the Act. However, the right to request deletion of personal data under the traditional data protection law is, in general, limited to data collected on the basis of individual consent and is subject to the needs of relatively broad secondary uses. It may not be sufficient, if so narrowly understood, to cope with the challenges we face today. So, sharing a similar appearance with the right to erasure. The right to be forgotten is very often considered to be new wine in old bottles to cope with the new challenge in an era of internet. So we have this right to de-indexing. Not only as a liberty right, but also a claimed right to impose obligation on others. Right to be forgotten is yet another exemplar of the right to control one's personal data. And this is what Professor Wong called the will conception of the right. This personal right is commonly thought to be the core of a more fundamental right to information privacy. Its multifaceted nature, however, suggests that right to be forgotten actually has many different roots and serves different interests. I think that seeing right to be forgotten as simply one expression of individual will or choice that conveys an agent's self-interest or preferences wrongly dilutes its real significance. Because right to be forgotten as such is no more than a permission or even an order to rewrite or erase history, merely for personal purposes. It could easily be outweighed by competing interests such as public's right to know or the freedom of speech that opposes obscurity and contests any form of censorship, as you can see in this scale. But I think instead, right to be forgotten should be understood as something more essential to democracy. I will suggest two possible understanding of right to be forgotten in this sense. First, when the modern concept of right to be forgotten was first introduced by Mayer Schönberger in 2009, the concept was closely linked to the right of oblivion, or what Professor Leo, the first Leo, mentioned, the redemption, the right to redemption. It's a right to request the erasure of one's criminal records after a certain period of time. Such an origin sheds light on our understanding of the right to be forgotten as a tool for social rehabilitation, which in turn is crucial for building a more tolerable society as a necessary condition for democracy. If the crux of the right to be forgotten is to ensure a clean slate for individuals after a certain period of time, thus allowing them to come back to a more solidary society, then current statutory laws apparently provide insufficient grounds. More specific clean slate legislations are necessary to complement a general idea of right to be forgotten. And second, right to be forgotten should be understood as a resistance to the threat to personal independence in an era of big data and algorithms. As individual behaviors, preference, physical conditions, and psychological states are all under the scrutiny and study of data technologies through profiling and machine learning, the threat to democracy is lurking behind subjecting one's independence to the algorithmic power. Right to be forgotten is in this light needed to maintain a minimum condition for democracy in which personal independence can still be possible. Such a revised version of Right to be Forgotten pushes us to think more deeply about the democratic values to which Right to be Forgotten can contribute, and to delineate more properly the extension and intention of the concept. And I believe only until Right to be Forgotten is so understood would it be possible to properly strike a good balance between the right to know and the freedom of speech on the one hand, and the right to control one's personal data on the other. And thank you. This is my commentary.
Thank you, Professor Chu. I'm sure your comment will not be forgotten by Professor Wong, so I'll give Professor Wong later a few minutes to respond to your comment and questions. And before asking our two presenters to respond to the comment by our two commentators, I would like to ask I would like to open the floor to everybody here for any question or comment or suggestion. And I see a hand. Judge Law and Albert. Okay, so Richard, Judge Law first, and then Professor Albert.
Thank you, Chairman. Two speakers, two paper presenters mentioned concurrently about some kind of independent and constitutionally mandated supervisory mechanism or authority. So these are my related questions. First, are you both referring to a single authority in our country, or are you thinking about the possibility of multiple supervisory authorities sharing the functions and duties for different kind of information, different kind of personal information or personal data, and for different kind of uses of such data? For instance, whether the existing NCC is suitable for this, whether the existing Fair Trade Commission is an appropriate candidate for sharing such authority. And secondly, it is about the point made by Dean Ji about concerning the attitude that should be adopted by the Constitutional Court, which is some kind of wait and see to postpone our determinative decision until things become clearer. But the point is, if there shall be a constitutionally mandated supervisory authority, then are we going to say the Constitutional Court, for instance, is the Constitutional Court being expected to say, well, you are, as the independent authority, you are responsible and you have the power to supervise the protection, but the substantive rules are totally subject to your discretion. In other words, when we are saying that there must be a supervisory authority, are we going to escape from our obligation, our duty, not to provide some substantive rules to be based upon by the supervisory authority? Thank you so much.
How about I let Professor Albert to issue your comment or question before I turn to your reply.
Thank you, Justice Wong, and thank you to all of you for your comments and your presentations. I have a question that is more particularized than abstract. It has to do with how to actually operationalize the right to be forgotten, how to make it work. The presentations and the comments were focused on, I think, the idea of the right to be forgotten at a high level of abstraction. And quite fascinating to hear that, but I want to ask you for your insights about how it can be applied. So for example, what do we do with ensuring that the right to be forgotten that is recognized in one jurisdiction is honored in another jurisdiction? So this, of course, is a question that is at the forefront of the dispute right now. So the right to be forgotten is a right that is recognized in Europe, but hasn't quite yet reached American shores. So what do we do if it's enforced in one jurisdiction, but not in another? Are you really forgotten? A second related question that is also more particularized and not in the abstract is, how far does the right to be forgotten extend? So one can order Google, for example, to remove from all returned searches a particular link. This is delinking, as you discussed it. But what about blogs? What about the fact that these sites can still exist, they can still be found, they're just not indexed on Google? How far does the right to be forgotten extend, and how enforceable is it? Is true and total and complete erasure really possible from the internet? I realize that I'm taking you away from the very important abstract and theoretical points that you've made, but I would really love your insights into helping me to grapple and think about this question. Thank you very, very much.
Before we have the third question or comment, and let me invite Professor Leo Chingy to respond to Justice Law's question, and then Professor Wong, please respond to Professor Albert's question, please.
Thank you, Justice Law, for your questions. With regard to the supervisory authority question, I think for practical reasons, a single independent supervisory agency is preferred here in Taiwan, because past experience have shown that we need to concentrate the experts and concentrate the resources to deal with personal data protection issues. Although I do share your concerns that maybe multiple independent agencies can have different expertise in different categories of personal data or the processing of different categories of personal data. But the current system, we have multiple administrative agencies to supervise or to enforce the Personal Data Protection Act. The result is not very good. So based on this experience, I think a single independent supervisory agency is a better approach. So they can accumulate experience and may have a better understanding of the overall problem we faced. With regard to your second questions, I don't believe that the current substantive right approach should be dramatically changed. I do mean that. I do not mean that. I think the current substantive rights form the baseline for judicial review, or form the baseline for the independent supervisory authorities to enforce the law. But I do believe that the Constitutional Court should not rush to add other specific or detailed requirements, substantive requirements in this regard. Especially, it should avoid making any absolute substantive rights in the future. So, for example, Professor Leo Chingy mentioned the right to opt out. I think probably the Constitutional Court should not require an absolute right to opt out. In some cases, for example, to prevent the outbreak of serious diseases, probably opt-out is not an option. And in some cases, I believe if irreversible anonymization can be really achieved, opt-out may not be necessary. But for other circumstances, I do believe that opt-out can play an important role. But I think the independent supervised authority can try to make detailed plan for this kind of right during the course of their operation. So the Constitutional Court can wait for their expertise and then decide and then act accordingly. That's my answer to your two questions. Thank you.
Thank you, Tingji. And then I ask Professor Wong to respond to Professor Albert.
Thank you for your question, but I think to that, first things first, I'll reply Professor Cho first. As the former assistant, I'll be very pleased to give or to return a very friendly feedback in relation to his challenges. To me, in the formula of the ECTHR assessment of the ECHR, the value of the democratic society has long been emphasized. I've shown that the interpretation of the rights in the GDPR shall be along with the ECHR and the formula. The right to delete itself is an actually multifunctioned right. I do agree that the RTBF to me is simply a remixed edition. The right to delete is not fully demonstrated with legislation and currently practicing in Taiwan. And under the broad conception of privacy and the protection of data, personal data, the function of social rehabilitation can also be regarded as a positive right of an agent to the needfulness of a generic condition of agency to grant the integrity of an agent. I mean, the mental integrity is also the needfulness of the generic condition of agency. This includes the social functions of what Professor Zhou Qiu has introduced. And then to Professor Albert's questions, how the RTBF to be implied. The question is actually very complicated because technically it will never be done because it is simply impossible technically and in a very natural aspect. However, what I should emphasize is that the right to be forgotten as a legal idea under the GDPR and the European model. For example, in the Data Protection Act 2018 in the UK, the way to prevent the identification is to criminalize if you act any the identification, if you try to re-identify that, this is simply a criminal act. So under the legal idea, it might be forgotten because you are not able to reuse the data again. But however, I do accept that technically it is nearly impossible, especially to the cross-judicial aspects. And I will also have some reply to the so-called independent DPA style. In the UK, the Information Commissioner Office is an institution that are responsible to several laws. For example, the FOIA and the Data Protection Act. In a single institution, it is possible for the institution to reconcile the competing rights inside the institution. So it is possible, therefore, to diminish the potential of the competing rights or the actual conflict later. For example, in Taiwan, I've always liked to have this example. Apps in the smartphones. We are hard to find single or one institution, a public institution, to regulate that. Because that if you try to regulate the apps, the NCC will say we're only do something about the internet platforms, but the content is not their responsibility. So maybe there will be a chance for a single authority to deal with that. That would be my thoughts. Thank you.
Thank you, Professor Wong. I wonder both discussants would like to join the discuss. Sure, please.
I would also like to make some response to Justice Law's questions regarding to the independence supervisory or multiple supervisory authorities. From my point of view, it's a bad policy to entrust supervisory responsibility to an agency which is in charge of matters other than information privacy control, because in that case, those agencies will collect data themselves, and who is going to supervise this agency will become a problem. So an independent supervisory agency exclusively responsible for the information privacy would be a better idea. And secondly, regarding the substantive rules that Dingji just mentioned, I would just like to add one point, is that the idea is proportionality principle. It means that the more compelling the government interest is, the more legitimate we can restrain or limit one's autonomy, no matter it's a prior consent or an opt-out in the later time. So I will agree with Dingji that in cases such as emergencies in public health crisis, we will simply taking people's information just like we will take the land for some public use. But that has to be some very compelling government interest. And in most of the time, maybe we should allow people to determine whether their worldview or their value system is inconsistent with the purpose that some data controller or data processor is going to use the data. So I think that goes back to the core of the proportionality principles. So that's the response that I would like to add. Thank you.
Okay, President Xu, please.
目前的司法院呢，正在重新检讨判决书公开的政策。我们现在就在讨论呢，判决书里面呢，原告、被告的名称在判决书呢公开，特别是上网的时候，是不是他的原告、被告的姓名也必须要公开啊？或者是呢，可以用 X、Y 或甲乙丙丁，来代替，特别是针对刑事案件的被告，他可能会有被遗忘权的需求，他以后他希望说他能够有更生、有重新融入社会的机会。那么，如果在 Google 里面呢，都可以以后随时都可以，他的名字都被查阅出来，那么对他以后他的融入社会是有害的。那么这个政策呢，司法院呢必须要做成决定，这个不能够再 wait and see。那个我们最近呢，也在举行这一个公听会了啊。不过呢，我想就趁这个机会，特别请教今天提出来的翁教授，还有特别是邱文聪教授。除了这以外呢，你们两位刘老师呢，要表示意见呢，当然很感谢。
Dr. Chen, please translate.
So the Judicial Yuan is now reviewing its policy of disclosing all the verdicts online. And we're debating whether the names of the defendant and the complainant should also be disclosed on the online database, or we should use pseudonames such as XYZ to replace their real names. And this is particularly a serious issue for criminal cases, for the defendants in criminal cases. The right to be forgotten should be helpful for their goals of social rehabilitation and reintegration into the society. But if we allow Google search to show their names in the future, that will compromise their opportunities. We cannot, as a judicial yuan, we cannot just adopt a wait-and-see attitude on this issue. This is very urgent, so I would like to use this occasion to consult all the presenters and commentators.
Good. We cannot wait to listen to Professor Wong's reply. Please.
Thanks to the question from the Honorable Judge Xu. Comparatively, in the UK, under the Civil Procedure Rules, Article 31 and Section 22, prohibiting the disclosure of a document or information to a person is possible as an exemption of the FOIA. The requirement is that the court should be satisfied that such disclosure would be likely to cause the person or some other person serious harm. And the second requirement is that the court having regard to the interest of justice, that it is proportionate to do so. So, 就是 in Chinese, in Chinese 就是说其实在英国在民事部分它的那个判决书的公开本来。依照他们的就是资讯公开法，政府资讯公开法 FOIA 2000年它是应该要公开啊。但是在公开的时候，它有一些公开的例外 exemptions， 譬如说这个法院它其实就很简单的写，那这个法院它的条件是设定说，法院满足于这一种揭露如果会伤害其本人或者是第三人的会对他们造成严重的伤害的话。或者是法院认为说这个基于司法的正当性这个比例原则，那其实因为法体系的关系因为法体系的关系，它还是用一个比较动态的 case by case 的那个 review 去处理这件事情，只是说这些 requirement 它会先设定在那边，就是不要让 如果会造成本人严重的伤害，那这个严重的伤害，它当然有很多相类似的判例啊，它不能够仅说因为我要更生。不过我还是要附带说明的是哦，英国一直在欧盟整个个资保护的这一个会员国里面，28个会员国里面，它一直都不是一个模范生，它一直都只是在最低的 requirement 那边，它不像德国人他们做的这么先进也有前卫哦。以上。
May I invite either Professor Leo Chingy or Professor Chiu Wen-chong to respond to President Xu's question first?
从社会复归的需求来看的话，很显然的，我们就可以马上区分出不同类型的判决：民事判决、刑事判决跟一般其他的行政法院的判决，在社会复归的需求上明显是不同的。那所以在民事大多数的情况底下，应该不涉及到这个社会复归的需求。那行政应该也是如此。那比较有疑问的，当然就是刑事的判决。那我的初步的想法是，刑事判决的公开，它当然必须是符合一个做一个公文书，它必须要因为判决刑事诉罪的目的有一个很重要，就是它作为一个规范的一个澄清啊，跟一般预防、特别预防这个需求，我们当然必须要在判决的当下，把相关的当事人的姓名做公开。那但是接下去的问题是说，这样子的一个公开资料，在后续如何被取得跟使用上面，我们现在并没有很好的后续的规范。虽然我们把犯罪的记录当成是个资法上面的特种个资，但是其实我们并没有很好的法律去谈说，在什么样子的情况底下，这种犯罪资料是可以被使用，或者是不能被使用。所以其实可能要从那个地方去下手，才有办法根本的解决。那就司法院来讲的话，能够处理的问题应该是说，刑事的判决在公开之后，它的 access 到底要如何去处理的问题，就是它当然在当下是可以是有包含原告包含这个被告相关当事人的资讯，但是在之后是不是要让它变成是一个database， 而且是永久都可以去查询得到的，这个在技术上面其实可以处理的啊，因为 right to be forgotten 当初在提出来的时候，它其实的隐含的一个概念就是在技术上面必须要内含着一段时间之后资料会被销毁这样的机制，所以这个是一个人为的决定。就我们一旦决定了某些资料在经过一段时间之后它会自动消失的话，其实可以透过技术来解决那个长时间之后我们需要被遗忘的这样的一个需求。谢谢。
Dr. Chen, please help translate.
I want to talk about just focus on the issue of social rehabilitation. We can divide all the verdicts into 3 categories: civil cases, criminal cases, and administrative cases. And for civil and administrative cases, they don't usually involve this goal of social rehabilitation. So what's really in question is criminal cases. And in my opinion, criminal verdicts as public documents, 公文书, they have certain functions, including clarifying legal norms and deterrence, general deterrence and special deterrence. So at the time of sentencing, such criminal verdicts should be disclosed. That's no problem. But the real question is how to use it in the period after the sentencing, after the disclosure of the criminal verdict. Now we don't have very good laws to deal with this question. And of course, criminal record is personal data. However, we don't have a good legal framework to deal with this specific question. So for your question, from the perspective of the Judicial Yuan, the question is, how do we regulate public access to such information after the sentencing? Should we have a specific database? All these questions should be addressed firstly from the policy point of view, because once we decide the policy, we can deal with them technically. For example, if you want to delete or set an expiration date for such data after a period of time in the database, that's technically possible, but I think the real question is the policy decision.
Professor Leo Chingy would like to respond to President Xu's question as well.
因为好几次开会都没有到，所以要在这边这个补偿一下，让玉洁有点事情可以做哈。我几个很简单的 point 就是，分类这件事情，我是同意文聪的。不过就是说，如果我们用 right for to be forgotten 的概念来看，那个分类到底要分到多细，案件类型到底要分到多细，或许是可以考量的。我现在没有一个确定的答案 ，OK？ 因为呢，我相信每一个人觉得他应该被忘记的案子或者事情，可能都不太一样。那我们在政策上到底要怎么做？这可能必须要好好去想一想。可能也不限于就是说简单的民事、刑事、行政法的分类 ，OK？ 搞不好有人觉得他吃一张罚单都很丢脸的 ，OK？ 好，比如说欧盟的那个 right forgotten 的最初的那个 case， 其实是一个破产的公告 ，OK？ 那我们会觉得这没有什么东西嘛，对不对？就是一个行政上面的一个公告而已。好，那第二个就是说，我觉得技术问题Google 或者任何搜寻引擎可以去搜寻到判决，单纯的这个理由不能够被当作不公开的理由 ，OK？ 必须要有更好的理由。意思就是说，其实在技术上面，搜寻这件事情 ，index 这件事情，其实是可以做某种解决的。那所以必须要更好的理由来谈这件事情。那当然就跟我刚刚所讲那一点是一样的。第三个，大家刚刚没有谈到的，就是说，一些相冲突的权益平衡的问题。我是一个很讨厌搜寻不到资料的人，因为我很喜欢搜寻资料。OK， 所以呢，资讯自由权这件事情必须要考量各种研究的权利，不仅是研究者的研究权利，一般人的研究权利，想要理解历史的权利。OK， 这些事情都应该被考量到。那最后就是在这么多考量底下，最后就是修法的问题啊。我们的资公法非常清楚的当然这也是一个大问题，把所有的机关都当作必须要主动公开这些公文书的机关，所以这一点到底应该要怎么办啊？这个可能要去处理一下。当然，一个可能的管道就是说，司法判决这个部分用一个特别法的方式来处理。OK， 那maybe 就可以去解决某部分的资公法的那个部分的问题。当然还有一个可能性就是说，那可不可以在资公法里面去加，就是说某一些司法文书基本上它是必须要有一个类似像所谓的到期日这样的概念，那当然也是可以的。还有就是刚刚所谓的敏感资讯、个资法律敏感资讯的问题，这个其实我们个资法整个的问题就是我们个资法都讲了一些大原则，事实上呢，全部都没有执行的方式，包括犯罪资讯也是一样。那也许如果司法院有心要做的话，应该顺便把这个问题也处理一下。谢谢。
So, I have several points in response. First is about the categories. I generally agree with Professor Cho Wen-Tong's categories, but I have further thoughts in terms of how detailed these categories should be. That's something we should consider because people have different needs for different cases that they want to be forgotten about. So for some people, maybe just a fine is very embarrassing. In fact, in the EU case, the first case that was associated with the right to be forgotten was just a public notice of bankruptcy. The second point I want to mention is the technical question. I think we cannot just say that we don't want to disclose the names. We don't want to be open about all the cases simply because you can do a Google search and find it. I think we should have better reasons to back our policy if we decide not to disclose the information in the cases. The third point is we need to emphasize the balancing act of different interests. The most important for me as a researcher is to find information in the public sphere. And it's not just scholars. Ordinary people also have the right to free information flow, the right to understand history, etc. The fourth point is about how to revise our legal framework. Right now, we have a law for open government information, and it applies to all the government agencies. But maybe we want to consider whether we want to enact a special legislation to regulate the disclosure of cases. Or we can think about whether we want to add expiration date as a legal provision in the current law for open government information. The final point I want to say is we keep talking about sensitive information, and it's in there in our personal data protection law. But in fact, in reality, there's really no very good practice to operationalize the definition of sensitive information. That's something we need to talk about to move forward.
Professor Wong would like to respond to, again.
I would like to have a quick response to President Xi and Professor Leo Chingy. In the UK, the law, as I have said before, provides rather rough principles and frameworks as well. But there are indeed a lot of good practice being issued to deal with that. 优良准则. But in Taiwan, I will just have a quick review. The good practice is practices are only in the fields of technical stuffs. For example, the drugs, the regulation of drugs, but not in the field of, for example, the FOIA or the DPA.
Thank you very much, and I note that there's not much time left, so I'll be very short. President Xi's question, I think, is a quite fascinating one about the responsibility to help socially rehabilitate those who make decisions that they will later come to have regretted. However, I wonder whether we should not be thinking about, in addition to the person who made the wrong decision at the time by committing the crime, and I think Professor Chu's three categories are very helpful to isolate it to the criminal cases. Those are the ones we really care about. But I wonder whether we should not be thinking less about the person who made this mistake than about the larger community who may have a right to know. I have a right to be forgotten in the EU. But my neighbors may have a right to know what I have done, especially when it comes to the raising of children in a neighborhood. In the United States, there are very intrusive rules about registration for those who have committed certain kinds of crimes. Precisely, President Xi, precisely, sexual-related crimes. As a parent, that's an important resource for me. It's important for me to know who is around my children, who is in my community. And that's what I mean. Just one example of where I, as a member of the community, have a right to know that I believe should trump the right of the individual to be forgotten. Now, this is my view, but one could imagine a balancing test where we balanced the interests of the individual with the interest of the community in knowing the information that the individual wants to suppress. And there's a larger, maybe public interest at stake as well, which is different from the interest of the local community. So I think President Xi's question is the question to think about. I'm just not sure what the answer is, however, which way the balance should fall.
Thank you so much, Rich, for your comment, because we are running out of time. But I want to do justice to Professor Liu by giving him a few minutes to respond to Professor Leo Chingy's comment previously, please.
Thanks for Professor Chingy Liu's kind words and challenging questions. I would like to make two quick responses. Regarding to your first question, Taiwan's Open Data Initiative under the regulatory context of GDPR. I think the biggest problem with these open data programs is the lack of prior data protection impact assessment. So they don't put the privacy issues at the center of the program as you wished. So a chance for the general public to review and comment on the privacy issues concerned before the project take place is very important for me. I think we can, within these procedures, we can carefully scrutinize the public interest asserted and the privacy enhanced techniques they employed. So that's why I propose that the Constitutional Court should consider a data protection due process. And with regard to your second question, the insufficient protection of sensitive personal data, I do share your view that the current Personal Data Protection Act has some flaws, especially Article 6 of the Act. Indeed, that article may provide less protection to sensitive data than ordinary personal data. But I think it's a result of rushed legislation and lack of consultation with relevant experts and civil society. So I think that can be improved in the future. So that's my two quick response to your comment.
Well, thank you. As moderator, I would like to thank again the presentation by our by Professor Wong and Professor Liu Chingy, and also the comment by Professor Cho and Professor Liu Chingy, and also the translation done by Dr. Chen. And also I would like to thank the audience for your excellent question, comment, and which made this panel so dynamic. And I'm sure this panel will be one not so easy to be forgotten in the future. Let's say, let me conclude this session. Thank you.